Legal complexities for foreign business enterprises hiring Canadian employees. Expanding a business into Canada with Canadian-based employees requires a thorough understanding of a legal employment system that is significantly different from many other international jurisdictions. Canada does not have a single unified set of employment laws that applies to all workers across the country. Instead, the vast majority of employees fall under the jurisdiction of the specific province or territory where they physically perform their work. This decentralized system means that a foreign country must comply with the distinct statutory requirements of each individual province in which it hires staff. Failing to recognize these jurisdictional boundaries can lead to immediate non-compliance with local standards. Each Canadian province maintains its own employment standards legislation, which dictates mandatory minimums for wages, vacation pay, hours of work, and overtime. For example, the requirements for statutory holiday pay in Ontario differ from those in Alberta or British Columbia. These statutes represent the floor of employment rights and cannot be waived or contracted out of by employer or employee. If a foreign enterprise applies a standardized global employment policy that offers less than these provincial minimums, those specific provisions will be deemed void by Canadian courts. This creates a complex administrative burden for foreign entities that operate in multiple provinces simultaneously. Beyond statutory minimums, Canada follows a common law system where reasonable notice of termination is a significant legal obligation. Unlike at-will employment found in various United States jurisdictions, Canadian employers must provide employees with either work notice or pay in lieu of notice when terminating employment without cause. The amount of notice required under common law is often substantially higher than the minimum set out in provincial statutes. Factors such as the length of service, the age of the employee, and the character of the position are used by courts to determine what is fair. Without a valid written contract that limits this entitlement, a foreign business may face unexpectedly high severance liabilities. Payroll administration and tax withholding represent another layer of complexity for foreign companies entering Canada. Employers are responsible for making specific deductions at the source, including federal and provincial income taxes, Canada pension plan contributions, and employment insurance premiums. There are also provincial-specific taxes, such as the employer health tax in certain regions, which are based on total payroll size. Additionally, workers' compensation insurance is mandatory and governed by provincial boards that require regular reporting and premium payments. These financial obligations require precise calculation and timely remittance to avoid heavy interest charges and legal penalties from the Canada Revenue Agency. The use of independent contractor arrangements is a common area where foreign business encounters serious legal challenges. Many international firms attempt to hire Canadian workers as contractors to avoid the administrative hurdles of payroll and employment benefits. However, Canadian tax and labor authorities use a multi-factor test to determine the true nature of the relationship, regardless of the title used in a written agreement. If a worker is found to be a dependent contractor or a de facto employee, the foreign business can be held liable for years of unpaid taxes, premiums, and benefits. This reclassification can result in significant retroactive financial assessments and damage the reputation of the enterprise with local regulators. To mitigate these various risks, it is essential for foreign enterprises to engage knowledgeable legal counsel to draft employment contracts that are specifically tailored for the Canadian environment. A well-drafted contract can provide the employer with greater certainty by clearly defining termination entitlements and protecting intellectual property within the limits of provincial law. These agreements should be reviewed and updated regularly to reflect changes in provincial legislation and evolving judicial precedents. Starting the expansion process with a legally sound framework ensures that the foreign business remains competitive while avoiding costly litigation that often arises from generic or non-compliant hiring practices. As such, when your international business seeks the professional services of an experienced Canadian business lawyer in the realm of employment law, we welcome you to visit our website and contact our law firm to schedule an initial consultation. Thank you.